Yeah, good afternoon. Thank you for joining us on our first in the series of webinars on protecting your business for growth. Delighted to be joined by Dean Hill and Frank Suttie from Freeths. Just before we start and I hand you over, if there's any technical questions that you've got during the webinar, you can put these in the chat function. Any questions directed to Dean and Frank, you can put them in the Q&A. Also, just for a bit of ease, if you click on our faces, you can drag the video to the top, just so they're not cutting the screen out. And I'll pass you on to Dean now. Thanks very much.
Thank you, Tom, and good afternoon to everybody. It's nice to see so many people attending what is the first in a series of webinars that focus on de-risking your business and achieving growth. Just a quick point to add to Tom's housekeeping. We're not expecting any fire alarms to go off today. And on the basis that we are all home working now, I'm afraid I have no idea where your toilet facilities are located. So at Freeths, we appreciate that running a business is never easy, pandemics notwithstanding. And as a dispute management lawyer, I spend a lot of my time helping businesses that I have come unstuck and unfortunately involved in a dispute. This can be a significant drain on a company's financial and management resource. And in most cases, there are a number of proactive steps that could have been taken to minimize this risk. What we're constantly seeing, unfortunately, is disputes involving supply of goods, supply of services, where no contract exists, or alternatively, a contract has been drawn up that's not fit for purpose, and written contracts that are legally up to date and fit your particular circumstances are an essential part of minimizing the risk of disputes arising in the first place, but also maximizing the strength of a company's position when the inevitable dispute does arise. The other point as well is that the contracts that stand up to the rigor of your business, they also add immediate value and make you a more attractive proposition to investors and purchasers. And what we're seeing in the current market is a more assertive approach to cash collection, certainly, a greater reliance on contract terms, and a lot of our clients coming to us and looking for advice about how and when they can look to terminate a contract that they might not be happy with anymore. But more importantly, if they do, what the financial repercussions could and might be for that business. So at this point, I'm going to hand over to my colleague, Frank Suttie, who's a director in our commercial team. And he's going to take you through some particular pitfalls that you can avoid, again, to de-risk that business and help you to achieve growth.
Thank you, Dean, and good afternoon, everyone. When we decided to do this event, there was one particular client that I've acted for that came very much to mind as a business that was very reliant on its suppliers and the performance of its suppliers. And I want to take you briefly through a case study about this particular business and then a particular situation. Now, to protect the confidentiality of the client, the situation is actually a made-up one, but it's very topical at the present time. But the attitude of this particular business to its suppliers and the contracts from the suppliers is the bit that's interesting. And then what follows on, it could be any kind of situation that arises where there's a problem in dealing with that supplier later. So let's think about this particular business. It happens to be in the business of distributing accessories and parts for electronics. It works with construction companies needing parts. It works with specialist M&E contractors and other businesses as well, particularly in manufacturing. And this company has a range of manufacturers that it does business with, so that it has got the right portfolio of parts and accessories for its customers. And every one of these manufacturers can appoint this business as its distributor. And that's good from both points of view. It first of all makes a supply channel for the manufacturer into the industries that it's targeting with its parts and accessories. And from our client's point of view, it gives them a certainty of a relationship of where these parts are coming from, so that they can engage in marketing, develop their distribution infrastructure, the logistics and so on, can all be based upon the fact that that distributorship is there. And distributorships obviously will last for a number of years. I went to see this client one day, and we started talking about one particular relationship. And the client, in a rather proud sort of way, I felt it was, said to me as he turned to a filing cabinet and opened the filing cabinet, brought out some documents and said, "These are my distribution agreements." I thought, fine, he's well organized here, he's got them all together. And he said to me, "I haven't signed a single one of them. I may have had queries back, I may have had someone say, 'Can you sign it?' but I'll just ask a question about it." And it becomes almost a war of attrition. And he managed to run his business. I suspect there would have been some documents, some contracts he signed, but he did genuinely say that there was a bundle of documents there that were left unsigned. And so he was really saying that he wanted to do business without worrying too much about contracts. Perhaps he even thought that he was doing business without a contract in place. But I'm sure you'll appreciate that that is never the case. The moment you start to buy something from someone, and the moment they start to sell to you and supply, there is obviously a contract falling into place. Now let's think of the scenarios that can arise in that situation. So we'll say this particular distributor has placed an order for some high value parts for an electricity distribution system. It's a particular customer dealt with regularly, and they're doing an M&E fit out of a district hospital. These parts are expensive, so they're therefore not kept in stock. They're ordered and delivered on a just-in-time basis, effectively, for the contract. The distributor gets an email from this company that's supplying him, and said that this particular part that they've ordered is coming from a manufacturing base in the north of Italy. And they've got a little local difficulty there, quite literally a little local difficulty. It was called a lockdown, something none of us had really thought about or experienced in any way at this time. And that the factory was going to be closed for 2 weeks. And I've seen an email saying exactly that from one particular client. And they were convinced they would be reopening again in a couple of weeks' time. So that's the way they were playing it. Now, this was a problem for our client. He was expecting the part to be available next Monday, and he was expecting it to be delivered. The logistics arrangements were all in place for it to be delivered the very next day to the hospital site. He was going to let down his customer, and that would have been a big problem because he started to look at the contract that he did have with the customer, and the terms and conditions didn't seem to be very helpful, shall we say, because this large contractor he was dealing with had imposed their terms on him, and strangely enough had made sure he did sign the contract. And there was something called liquidated damages in it, which worried him a bit. So he goes off, and he's got other potential sources of parts that would meet the specification. And thank heavens he finds an alternative supplier and gets that supply at some expense, needless to say, delivered to him on a particular day, the Monday, and then it's off to the hospital site on the Tuesday. Job done. He sits back. Well, that was a close run thing. But then, of course, the Italian manufacturing plant is still thinking it's manufacturing this part for him. And 6 weeks later, it actually arrives. And so he says, right, what do I do in this situation? And there he might want to look at his distribution agreement, and he probably finds some provisions about cancellation, some provisions about force majeure, and so on, which he's never really looked at before. And he then finds that he's got an issue. Can he actually persuade the manufacturer to take the part back? It's a high value part. They wouldn't be terribly happy about giving a credit. And what about things like, there's a reference to a restocking charge, which seems very, very substantial. And these are the sort of issues that do come up in a supply chain. And in a situation there where he hasn't signed the contract, he hasn't got familiarity with the contract terms, and maybe also these terms, don't actually relate correctly to the way he wants to do business with his customers. So we're going to look at, as we go into the presentation, and we'll look at three different items in the agenda, which is just about to come up on screen. And these are the kind of issues that we're seeing quite regularly when we are looking at helping businesses with their supply chain. And here's what we're going to cover in the next 20 minutes or so. First of all, ensuring that trading contracts are fit for purpose, keep your suppliers on the terms you demand. We all know that trading online is becoming a big thing, and there's a lot of focus on trading with your customers online, particularly if the customers are consumers. There's legislation there. But for this session, we're going to look upstream, and it's when you're trading with your manufacturers is online as well, and some of the issues to watch out for there. And then, as we've seen through the COVID-19 episode that we're currently part of, sometimes contracts just can't be performed, and you're faced with a supplier saying to you, sorry, we can't perform the contract on this basis. We want to perform the contract in a different way. So let's take these particular issues one by one and see what conclusions we can reach from them in terms of managing these kind of risks in your business. Right. My case study was very much around a business that liked to tuck contracts away almost in an out of sight, out of mind basis, and maybe not even thinking through analytically the fact that, as I've already mentioned, that there will be a relationship in existence of a contractual nature. We all need to remember that contracts can exist even if they're not documented, and so you can agree just literally with a handshake. Maybe pre-COVID, we'll think twice about the handshake now, but people can be bound to do things. Under English law, the only thing that's expected is that both parties are giving consideration. So each party is giving something to the other, and then provided it can be evidenced, then it's a contract. But in business dealings, it's so important to actually have that business dealing documented in an actual contract. And so the world now rotates around, in business terms, contracts and commitments made and documented through these contracts. If it's not documented in the sense that you haven't signed the contract, as with my case study, then there's a fair chance that it is still going to be treated as documented, and most probably on the terms and conditions that are sitting in that filing cabinet drawer. Because the person who chooses not to negotiate the contract, who is happy to sit there and do business without reference particularly to the contract, is going to struggle if there is then a dispute. And the customer says, sorry, the supplier is making a point perhaps to its customer, to the business that we're thinking about just now. Well, you agreed this, you agreed that, and any attempt to say, no, we didn't, is, I think, going to receive short shrift if that becomes in any way litigious. Because, of course, there are very clear contract terms that are sitting in a drawer and have not been challenged. So, undoubtedly, trying to disregard the fact that a contract document has been provided is not going to be good practice. There's then the issue, which I'm sure you're going to love hearing about on this particular webinar. It's the one issue that always causes shall we say, an intellectual challenge to lawyers. And that is, are we trading on their terms or our terms? If it's a distribution type arrangement, then most likely you're trading on the manufacturer's terms because of their leverage, if you like, over the supply chain. If you don't like the terms, they'll go off and find someone else to distribute their products. But sometimes the supplies that you're bringing into your contract into your company might be a bit more ad hoc, and you've got a situation where you've got on your order forms, when you place the order, now here's our terms and conditions of purchase, please respect them, look at them. They are the terms that we're buying on. And even if when you accept our order, you attach your terms and conditions in return, well, that's got to be disregarded. Now then, we're into what's called the battle of the forms. And I'm going to give Dean the chance to actually come in on this, because when it does become a real battle, then it's really important to understand what makes up the contract. And it's not just the terms and conditions frequently, as I think Dean's going to be able to explain.
Yeah, thanks, Frank. Yeah, the Battle of the Forms is called the Battle of the Forms primarily because it very, very quickly becomes a very difficult and entrenched battle to have. The reason being is what you normally see are that the two parties' positions per their terms and conditions are so diametrically opposed that in the context of a dispute it puts a completely different slant on quite honestly who's going to win and who's going to lose out. And this is a situation that I'm currently dealing with, where it's in the manufacturing sector, and it's not unusual to see in this sector a number of quotes, proposals, purchase orders, agreed variations going back and forth between the parties, all of which seek to incorporate that party's own terms and conditions. And in my particular situation, we're now left with a position whereby in excess of £750,000 has been paid over for a bespoke piece of equipment, a piece of machinery in this case, and it should have been delivered back in 2018, which, yeah, nearly 2 years ago now, and it hasn't been. And the manufacturer is able to try and justify that position by saying, well, we don't have to deliver it because according to our terms and conditions, time is not of the essence. Whereas, funnily enough, our terms and conditions require delivery by a specific date. So because we have this battle of the forms, we have a situation whereby either something should have been delivered 2 years ago, or something can be not delivered, despite the fact that, yeah, £750,000 has been paid over. So trying to unpick that timeline of events and the documents to work out who's right and who's wrong, or who's going to win or who's going to lose if it goes to court, is a very difficult and time-consuming task, which creates uncertainty for everybody in my litigious world.
Thank you. Yes. So it certainly is difficult, to say the least, to actually develop a position that is clearly going to be the one that wins the day at the end of the day. And it certainly does require you to pay attention, I think, to the issue of making sure that the paperwork that becomes the contract is there on a basis that you want. I've said this at the final point: do you have certainty in contract terms? And the prompt for this is a change that has arisen over the last few years in the attitudes of our courts when considering breach of contract cases and claims under contracts. And a lot of us as lawyers were brought up to understand that the way we crafted the words in a document was going to be paramount. We had to be very, very careful. I had a salutary lesson right with my very first contract I drafted. It happened to be a shareholders agreement where a dispute arose, and the dispute did actually end up in the courts. And pleased to say that my clients won the day at the end of the day, but it was very important to have made sure that the contract terms were stating clearly and ideally unambiguously what you want to achieve in the contract. What's been happening over the last few years, though, is an attitude on the part of the courts that they're more willing to accommodate suggestions that the contract terms go beyond what's actually written. And I did some more looking around on this issue last night, really to make sure that I was going to present this issue correctly. And I spotted the fact that a case that actually we've been involved in is Bates versus the Post Office. And you'll be aware of the rather disappointing case of the IT system that the Post Office was using, Horizon, and where many, many postmasters and mistresses ran into big problems with the Post Office because of issues that arose on that. And that had to be litigated on a number of fronts. and one was the actual contract under which postmasters and mistresses were appointed. And a key point that had to be asserted in that was that the post office was not acting in good faith. And it wasn't in the contract. They had to act in good faith. So there would be shock on their part, bewilderment on the part of their barrister. What's all this about good faith? But what then came into play was, first of all, there was nothing in the contract to say that good faith wasn't a consideration. You know, if there was in the contract, we can run this contract as we want to. Don't ever come with an allegation we're acting in bad faith. And there was nothing to suggest that it wasn't going to be operated on a basis of good faith. And it was a long-term contract, and it required the parties to perform roles with integrity and fidelity, was the view of the court. There was no point in entering into a contract involving very significant financial liabilities if the parties weren't acting with some degree of fidelity. And so this is telling us that the courts are now willing, despite things like an agreement, an entire agreement clause, despite not putting into the contract, we will act in good faith at all times, the courts are prepared to look at things differently if they feel that there is some imperative for doing that, if they feel that one party is perhaps taking advantage, shall we say, of the contract and taking advantage of situations that the contract isn't specifically addressing. And it's also the case, there's an old-fashioned concept within the law of estoppel, where you can help, with the support of a court, you can stop a party from taking advantage of a situation in a quite contradictory way to what they said before. And that's been, in a case back in 2015, used to actually allow a pre-contract agreement to be taken into account. So the pre-contract agreement, heads of terms, a memorandum of understanding it might be, was produced to the court, and it was shown that the agreement didn't specifically deny the existence of the understandings within that, didn't contradict the understandings in that. So why should someone within the contract try to use the contract in a way that was contradictory to the memorandum? And so estoppel becomes a consideration there. So we're into a very interesting world of where our contracts have actually got less certainty around them. But again, it does mean building up the case for your part of the contract as clearly as possible. Then if we go on to the brave new world of electronic commerce or e-commerce that we're into, what's different about trading online? Number one, notably, there's less paperwork. That's probably a good thing. And instead of the paperwork, obviously everything is now based upon databases and emails, and keeping track of all the information around a contract does perhaps become more challenging as a result of that. I've posed the next point that perhaps there is less certainty in the contract and the contract terms. A particular client that I'm working with just now happened to mention that they're putting their standard terms and conditions of business on their website, and they don't now propose to have them printed in any way. The customer will be constantly referred back to the website. And you could imagine a situation arises where, shall we say, there is an order for goods that have got to be provided on an installment basis over 6 months, and that contract was maybe signed in February with the first installment due in March. And then we come to July, and there's a problem in the manufacturer fulfilling the order at the present time because of circumstances, and they point to their terms and conditions with their rather favourably framed COVID-19 provisions. And you look at this as the customer, a bit bemused, because you think that they must have been really quick off the mark if in January they had all this in their contract terms. Fortunately, you've managed to draw down and you've held a copy of the terms and conditions as they were on the website in January. And you find that clause 21 is not there. There is no clause 21. And what you're looking at is a version of the terms and conditions that were posted on the website in May. several months after this contract started to be performed by the parties. Now, there is a school of thought that says that you can change contract terms, but that is I think, very much capable of being challenged, particularly if one of the parties is on the receiving end, shall we say, of the contract. You're receiving in the sense of being provided with goods in installments, and all they have to do is make a payment. And in that situation, trying to suggest that the contract terms that were agreed in January are not the contract terms applicable in July doesn't sound right. It could be different if both parties are trading in a way that's more dynamic. Perhaps there are things being agreed as you go along. Perhaps it can be shown that the buyer was aware of the change in the conditions and hasn't challenged that in any way. Even that, again, if the customer has nothing else to do in the contract apart from make payments, receive the goods, make payments, even that must be tricky. So I don't subscribe to the school of thought that you can change your terms and conditions by posting them on the website in a new form, unless you can somehow get the customer to agree in a legally effective way to these changes having effect. So we're certainly into more dynamic relationships as a result of e-trading. And within these dynamic relationships, there's going to be more just-in-time ordering of goods. It's probably amazing to think back. We've had probably just-in-time manufacturing concepts in use in this country for probably about 20 years now. But if just-in-time manufacturing and just-in-time selling has ever reached a point of almost being an expectation, it certainly is now in the 2020s, when we've got in our consumer lives, we've got Amazon delivering within hours of an order being placed. And this does make the idea of electronic trading, and the fact that you can place orders 24/7 any time of the day, does make life, certainly in many ways, a much better experience for those involved in supplier relationships with manufacturers, where you've got a customer wanting goods and wants them delivered very quickly. But do the terms and conditions of business actually stand up to meeting these expectations? This is one of the areas that you undoubtedly will want to look at if within your business you are working much more agilely. And as long as everything is going fine, that's great. But then if problems arise, are the terms and conditions going to stand up to muster in that situation? I've added also that you've got more control over your purchase order. And that means that, again, through electronic trading, you're inputting more data about the order that you're placing. It could be some specifications, some characteristics of the product that's being ordered. And that creates better evidence, shall we say, of what you're ordering when it comes to delivery. And so if you want to reject some goods that have been delivered, it could be that you're in a stronger position than if the order was made over the telephone, say, where there's going to be much more difficulty assembling the evidence around what you're purchasing. And then we'll move to the final thought for the day in terms of supplier relationships. And this is undoubtedly the most topical one at the moment. Is COVID-19 a valid excuse? Well, the example I gave, which, as I said, I'd mixed a couple of scenarios together with it, but yes, there was a client of ours that received a notification from a company that its order wasn't going to be delivered within the next fortnight from the north of Italy. And what it has led to in many, many businesses is looking at the way in which force majeure is used to advantage. Dean will say a bit more about force majeure in a minute, but just to put that in context, one thing to understand is that force majeure, it sounds like a legal principle, but in fact, it's a term of the contract, no different to any other terms that you're working with. It has to be crafted in a particular way. I've only this morning had a call from a client where we've been helping them with a force majeure clause, where we've introduced the right to suspend performance, terminate performance, And the client's a bit flustered because the other side have come back and said, can we have the same right, please? And the client hadn't really thought this through, but in fact, they're in contract negotiations. And so a force majeure clause is really no different to the other one, and it has to be customized. And Dean, I think you've got something to say about this as well.
Yeah, it's an issue that cropped up on a matter that I recently dealt with. Not COVID-19 specific, but obviously the current pandemic has brought force majeure clauses to the forefront of people's minds, because we have a wide-ranging situation that is affecting a lot of people, and a lot of people are being put in a situation where they're going to struggle to comply with their contractual obligations. But in my particular situation, we had a contract, as daft as it sounds, for a concert that was meant to take place on a beach, and ultimately the concert organizer terminated the contract because they said that an act of God had occurred, thus enabling them to terminate the contract without any sort of penalty or liability to the client. And this goes to your earlier point, Frank, about uncertainty and how courts can and are prepared to look at what might not be in the contract as much as what actually is in the contract. And that sort of applied in our circumstances, because we had an express force majeure clause in our contract that was quite specific in terms of the events that would trigger it. And in this particular clause, it referenced an act of God, a natural flood, fire, lightning strike, earthquake, pandemic, illness, war, and military operations, and that was it. And the reason for the termination of the contract in our circumstances was because of a high tide on the beach. And because the clause had been drafted in such a way that it was quite specific in terms of what constituted that force majeure event, it enabled me to say, well, a high tide is not a natural flood. It's fundamentally something different. And therefore, because you've made express reference to natural flood, your high tide occurrence is not an event that triggers your ability to walk away under the force majeure clause. And at the very least, gave the client a foot in the door to make that argument and to make that point, and if nothing else, to bring the parties to a negotiation around a table whereby we at least had an argument that we could run, because there was an express clause, and I was able to use what wasn't in the clause as opposed to what was in the clause. And it has a significant financial, obviously, effect on the client's position, because the concert organizer felt that it could terminate the contract without any penalty, whereas we were able to put the client in a position where we could say, well, actually owe us a sum sort of in the region of six figures. So it can have a big impact, and obviously that's what we're seeing a lot of in the market at the minute with COVID-19 particularly.
Yes. Okay. So, well, there was a client that wasn't left high and dry, shall we say. Right. So James really dealt with the second point there, and that is that renegotiation of contract terms is always possible. You know, there's usually something you can do to actually do something in terms of improving a position that you're in that might have been a difficult one. So yes, a deal is a deal. That's always going to be said to you. We shook hands on this in the good old days when we could shake hands. But yes, there are ways of finding a basis for renegotiation. And as the final point says, you know, are you looking for something that's not in the contract? If the other party wants something, this is the time for you to be opportunistic as well. But of course, the final point on that has to be get it in writing. Make sure that the writing that you do refers back to the agreement itself, and ideally acknowledges that there was an entire agreement clause in the contract. Anyone looking at a contract, you're forgiven if you get a bit fatigued when you get towards the end and you've got a bit more excited now than you might have been previously about the force majeure clause. You come to clauses about serving notice, you come to clauses about assignment and change of control, and then you come to this one called entire agreement. Well, that's there for a reason, obviously, and that reason has become more important given what I said earlier about ensuring certainty in the contract terms. And you now have to do a bit more, I think, to ensure that certainty. And so certainly if you're trying to vary an existing contract, what you should be doing is certainly referring back to the contract, and in particular the entire agreement clause, and making clear that what you've just agreed with the other party is now part of that contract and is absorbed into that contract. So I hope that's been useful in terms of giving you some of the things that we're dealing with, some of the war stories from the present time, and good luck with your contract deals going forward. Thank you.
Well, thank you very much, Frank. The next part of the webinar is we have a question and answer session, and as Tom mentioned earlier on, there is the ability, technology-wise, if you would like to post any questions, they should appear on Frank and I's screen so that we can try and give you some guidance. At the same time, we've also had some questions sort of sent in advance. So again, thank you very much for those. So the first question we've got is, I keep seeing retention of title references in my supplier terms and conditions. I sell on goods received very quickly. How am I supposed to pass on ownership in that kind of situation? I think that's something you touched on earlier, Frank, isn't it? Is that something you want to pick up on?
Yes, yeah. This is, again, one of these long-standing issues that always features when discussing contract terms and conditions. Retention of title is something that is fully accepted, acknowledged, and recognised in any contract where it exists. And it's complicated to enforce, complicated to administer as well in many cases. And where the party who has agreed that the supplier has retained title, in other words, legal ownership, notwithstanding that risk is transferred, because keep in mind there's two separate concepts here. Who carries the risk of something happening, accidental damage, the goods being stolen? That's the risk element of it, but the legal ownership is an entirely separate concept. And the dilemma for someone in a distribution role is that obviously they want to stock the product for the minimum possible time. They want to get revenue back for that product as quickly as possible. And how can that happen in a situation where, as a matter of law, you must warrant title, you must be committing to giving title to another party? And what we seek to achieve when we're working particularly at the distribution level in the supply chain is make sure that there is a provision in the agreement, as there should be, and this is now market, you can expect this from your manufacturers, that nothing about retention of title in any way prevents you from honouring the transfer of ownership to another party as you sell on the product. And where we find the thinking goes after that, if that's accepted, is that it really does come down to credit control and assessing the creditworthiness of the distributor in the middle of the chain, because there's no point in building the business relationship on the basis that, yes, you might have £120,000 worth of stock with that particular distributor at any given time. And yes, you're going to get exactly that £120,000 of stock back, if necessary, by just sending lorries down to the warehouse to collect them. The real world isn't going to work that way, clearly. And so retention of title is valuable in many, many cases. but is not the only way to actually protect your business. It's down to credit control as well, clearly. Hopefully that helps.
Thanks, Frank. I've managed to work out the technology, which is a surprise in itself. And we've had a question posted. What are liquidated damages, which you mentioned? I think that's one that I can pick up on. So again, liquidated damages are the parties to a contract, again, trying to import certainty into their contracts. And in particular, the parties setting out in the contract in agreed form what the damages will be limited to, should that one party will have to pay to the other in the event of default, effectively. So again, it's about importing certainty into the contract so that if a dispute does arise, the contract can't be performed and one party sues the other, that the parties know what their exposure is in such circumstances, because they have already agreed effectively a limit on what those liquidated damages are, so that the parties can then enter into the contract with their eyes wide open, knowing full well that if this goes wrong, if for some reason we are unable to perform and the contract is brought to an end and we are liable in damages to our contracting party, we know what that check or how big that check is going to be. So therefore we can factor it in to the price, for example, that we may put forward under the contract, so that we can sort of measure the upside against the downside if the unfortunate does occur.
Yeah, thanks. And apologies I didn't mention that or explain it earlier. And actually, one thing that occurred just a couple of weeks ago in a contract that was being negotiated was this very issue of inserting a provision for liquidated damages. And we left it to the other party to draft the clause. And they duly did that. And they put a heading on the clause when the agreement came back to us, which said penalty. Now, maybe they thought they were being cleverer than us in this and that we would accept this. Yes, it is a penalty. Clearly, if something's gone wrong and something hasn't been supplied when it should have been supplied. But the other side of the coin to liquidated damages, as Dean was explaining, is that it's a measurement of the losses and the management of the losses. And if you get carried away and put in liquidated damages in an agreement that are far in excess of anything that represents a reasonable accommodation of loss and so on, the courts will call it a penalty. And I think we were being tested out there in a rather bizarre way by these other lawyers, and we had to strike this out. No, this is not a penalty, this is liquidated damages. That was quite bizarre, that. I've never had that before. It's interesting it's come up just before this event. Okay.
I'm going to a couple more questions if we've got time. Again, it's all about you, Frank. Frank mentioned 3 options when receiving standard form supplier terms. Why would we pay for our lawyers to review if they were truly standard form? Well, I can start off on that with my dispute management hat on, which is that the simple answer really is that they are the supplier's terms, and therefore they're going to be highly stacked in the supplier's favour, and therefore not yours. So whilst they may be standard, you still want to have a look at them at the very least to establish what your downside is if things go wrong, on the fair assumption that you are likely to be the one that loses out.
Yes, this was the distributor that puts the contracts away in a drawer and doesn't look at them. And it's really a case of what is he missing out on. And what he's missing out on is clearly, first of all, understanding how that relationship is meant to work in practice. But he's also missing out potentially on weaknesses and understanding some weaknesses in the contract. Some contract terms can be struck out as being unreasonable, and we've looked at that actually just in the last few minutes in this distinction between penalty clauses and liquidated damages clause. If a liquidated damages clause is drafted to penalistic, then it'll be struck out. But there's also competition law considerations can come into play. If the manufacturer is expecting too much of you in terms of restricting your activities outside of that contract, that can sometimes be something that can be brought into question. And perhaps it's going to be obstructive to you developing your business if it's not actually questioned. And watch out also for whether what's called a red pencil provision has been put in around restrictive covenants, because if the restrictions in a contract preventing you to do business with their competitors, perhaps, preventing you going to other areas of business that the manufacturer doesn't want you to go into because he's perhaps got another distributor down the road that he wants to favour in that, then the ability of the court to actually treat the whole contract as unenforceable is going to be there, unless there's a red pencil provision, which is the key way that lawyers work to make sure a contract survives, even if something in it is actually challenged later and that challenge is correct, and a particular provision is found to be unenforceable, it maintains the rest of the contract in place. I think that covers that point, Dean.
Thanks, Frank. We've had another question as well, which he's got time to squeeze in as well. This is something we've touched upon but not gone into any great detail. But we've signed a contract with a supplier, but we now want to get out of it, as we've discovered certain things that mean that we wouldn't have signed a contract in the first place if we'd have known about them. Is there anything we can do to effectively get out of that contract? Well, again, with my dispute management lawyer's hat on, this is a regular occurrence. I think the starting point, I would say, is that a court will not interfere with a contract that has been sort of freely negotiated between two commercial parties, and it won't set that contract aside simply because it might be a bad deal commercially for one of the parties. But I suppose the good news is there are provisions that enable the courts to effectively rip the contract up, throw it in the bin and deem it never to have existed. Or alternatively, there is scope for a court to sort of set aside, delete particular clauses in a contract that might offend particular statutory requirements, such as Unfair Contract Terms Act, which I'm sure is a term that a lot of people will be familiar with. And I think, again, touching on Frank's point about trading online, is that if you are dealing with consumers, which is basically individuals who are not contracting with you in their usual sort of, or for the purpose that they usually sort of carry out their business, then you do need to be extra careful with the drafting of your contract terms, because those consumers are afforded particular protection under Consumer Act or consumer rights legislation, and therefore you've got to be careful that you don't offend those statutory provisions, which again, if you were, for example, were the consumer, would give you the ability to get out of the contract if all the boxes haven't been ticked in that respect. Again, I appreciate that we haven't really touched upon or dealt with complete termination on today's session, but I'm sure that's something we can follow up with you if you would like, and give you some more pointers as to where a court might be prepared to, say, tear up a contract for you.
Mm-hmm. It's interesting that we have someone who's obviously committed to a contract with expectations that, by the sounds of it, are not going to be delivered, shall we say. And it does go back to that case that within Freeths we're very familiar with, the Bates and Post Office case. And if it's a long-term contract that's been signed up to, or an expectation of it staying in place for a long time, the key point within Bates that I didn't perhaps mention is that the concept of what the courts called a relational contract, where this isn't just about buying staples or boxes of paper or something very generic like that, where there's multiple sources of it and you can switch from one source to another the next day. The courts were amenable to looking at contracts which are obviously intended to develop longer term relationships. You might be able to demonstrate to the court you're investing in the contract, you're actually spending money to actually make this contract work. And that would be one of the things. And I've got on screen the key criteria of what the court said was a relational contract. I've touched on one of them already, the good faith point. I think I touched on integrity and fidelity being something that could legitimately be expected. But there's also a commitment to the parties to collaborate in performing the contract. Are there things there where the parties actually said they would do more than just supply goods? They would do other things on a collaborative basis. Does the contract really have an expectation with it of a high degree of communication, cooperation, and predictable performance based on mutual trust and confidence? And the exclusivity of the relationship will be a consideration as well. So, in that situation where you're maybe perhaps regretting having entered into a contract, maybe it is worth looking again at, are you getting the expectations out of the contract you were entitled to? And that will be a very relevant consideration.
Yeah, thank you very much, Frank. Well, I'm looking at my watch, and I think that that's brought us nicely to the end of today's webinar. Again, just to thank you all for your time and for joining us today, and also for your questions, which hopefully we've been able to answer. Obviously, hopefully it goes without saying that if anybody has got any further questions or needs any further help with anything, then please do reach out to us, either myself or Frank, together with the rest of the Freeths team. We're more than happy to have a chat with you and see if we can give you any pointers. Moving forward, as I said earlier on, this is the first of a series of webinars, and hopefully you'll be able to see on your screen that our next webinar is on the 28th of July, so what, a couple of weeks away now, 3 weeks away, whereby our focus then will be on the world of employees, employment, and how you can protect what effectively is a significant asset, being your workforce, via employment contracts, directors' contracts, and my colleague Toby Pochran, who will be joining me for that webinar, will be taking you through how we can de-risk and protect those business assets in particular. And we will send out details for that webinar to you all very, very shortly. So again, thank you very much for all your time, and we look forward to seeing you next time.